Welcome all of you to the fourth panel already. I think that it's the last one. That's the most interesting one, probably, because then the real issues come will be presented. And that is, of course, the theme of the conference, which is coherence. And this coherence is, it's always used a lot. The word is very often mentioned, and the virtue of coherence is cherished widely. Everybody is talking about coherence all the time. But if you look closer, it is the most nebulous concept you can come across. It is not clear whether coherence is the same as consistency or not. Well, it's a question that will be addressed by Giannakopoulos, as I understood well. It is not clear whether it's different from non-contradiction. It is not clear how it relates to predictability of the law. So you might think sometimes it's just a buzzword in order to mask, in a rhetorical way, to mask all the disagreements and the opposition of interests and clashes, in order to make it to sweep that under the carpet and to turn it into some smooth unity. So it is the most intriguing, I think, one of the most intriguing puzzles that we are addressing in this panel. And I'm very glad I don't have to chair this. We have found Mrs. Freya Baetens. She is, I think, expertly suited to the task of chairing this probably very confusing and very intriguing sessions. Mrs. Baetens holds a chair in Public International Law at the Oslo University. She's also affiliated, I saw, in Leiden. I didn't know that, so I'm intrigued to know more about that as well. But let's go first do business, and I'd like to give you the floor, Mrs. Baetens, in order to arrange and to regulate this confusing, more or less philosophical debate. Thank you.
Thank you very much, Ms. Westerman, for this kind introduction. I would say, without further ado, let's start with the first speaker, who's Charalampos Giannakopoulos, and he is a research fellow at the Center for International Law at the National University of Singapore, and previously obtained his doctorate from the Graduate Institute in Geneva, and that was on the topic of manifestations of coherence and investor-state arbitration. So I'm not surprised at all that you were invited for this particularly interesting and challenging panel, where he will discuss in particular coherence and practical legal reasoning, goal methods, or both. Charalampos, please, you have the floor.
Thank you, Professor Baetens, for your very kind introduction, and thanks, of course, to the organizers for inviting me to present on this occasion. My intervention today has a bit of an introductory character, and I believe in some parts it will perhaps recall some of the remarks made yesterday as well. I should say I come to this topic as a bit of an outsider to customary international law. And my purpose today is really to sketch out conceptually how coherence interpretation and customary international law could perhaps relate to one another. My main point would be that coherence in the interpretation of law and, of course, of customary international law is possible. But it may not be the kind of thing that most people would instinctively think. And in particular, my point is that coherence is not simply an abstract goal, but also a method of work and of legal reasoning. And a second point I wish to make is that when interpreting customary international law, it is perhaps three processes that can account for the perceived coherence or incoherence of the interpretation. And these processes we could broadly call framing, contextualizing, and being reflexive. And moreover, these are processes that I think are more generally key in all aspects of legal reasoning and interpretation. So a first question to ask really is how to conceptualize coherence, because often coherence in law is, as Professor Westerman said, subsumed under related concepts like consistency, predictability, or correctness. However, I don't think it should. And so the definition of coherence I will be using as a starting point or launchpad here is the one used by Neil McCormick, who defined coherence as axiological compatibility between two or more propositions. So for McCormick, coherence describes a situation where two or more propositions fit together by appeal to an ordering value or an ordering principle. That is to say, they are rationally related to each other and to the values or principles that are thought to justify them. Therefore, coherence paints an image of a web or a network of reasons rather than an image of a linear justification. As such, coherence is different from consistency in that consistency is a logical property that obtains in the absence of contradictions, whereas coherence is a matter of degree and justification. Furthermore, whereas consistency tends to be morally agnostic, coherence is not. And again, this is because it depends on justification and what McCormick called axiological compatibility. And therefore, what may appear inconsistent may in fact be coherent if we go higher in the level of abstraction and look at governing principles or perhaps justifying values. And similarly, what may appear consistent on a first reading may in fact not be coherent if we do the same thing. And by the same token, I think coherence is also different from predictability. I take predictability in law to describe a situation where answers to questions are forthcoming and certain with perhaps little to no gaps or ambiguities. But of course, law can be more or less predictable without necessarily being incoherent. We may not be able to predict with 100% certainty the outcome of a judicial decision in the ICJ or in investor-state dispute settlement, for example. However, this does not mean that the decisions that we do have lack incoherence or plausibility or even legitimacy. What is more, changes in the settled law of a legal system over time through progressive development, which may lead to less predictability for some time, are not necessarily, I would think, a sign of incoherence. And to the contrary, they may make law more coherent over time because, like consistency, I take predictability to also be a bit morally agnostic. Now, the relationship between coherence and correctness in law is, to my mind, a bit more complex because in law, correctness cannot be reduced simply to the pronouncement of an outcome. It is the process of reasoning towards the outcome that matters a great deal as well. Therefore, correctness in law, I think, can be described as being both determinate and demonstrable. The correctness of a legal outcome is determinate, I think, when the reasons supporting it carry the greatest weight out of all competing plausible reasons in support of the same or another outcome. Therefore, determinate correctness depends principally on the substance and the strength of the reasons offered. For example, on their abstract moral appeal or the degree to which they conform to past practice. By contrast, the correctness of a legal outcome can be described as demonstrable when its determinate or at least plausible correctness can be demonstrated to the satisfaction of everyone, or at least virtually everyone. And this means that demonstrable correctness depends principally on the method used to arrive at the reasons that support the outcome that we argue for. Now, because coherence is axiological compatibility, we may say that it is linked to correctness in the following manner. There may be different interpretations of a single legal norm, which may all have a claim to correctness, but one of those interpretations may still be thought to cohere better than another, given the substantive justification offered for it, and given the process followed to arrive at it. In other words, what is an otherwise well-conducted process of justification may still result in a decision with which at least some may disagree on substance. And conversely, a morally correct outcome to which everyone would agree that the law should provide may have been the result of a contradictory reasoning or of a not well-justified process. And I would think that coherence would be affected in both of these situations. And therefore, to briefly recap on this point, coherence means the axiological compatibility between propositions and conjures up images of a network or a web of justification. It obtains in degrees and therefore has an argumentative character. And in the legal field in particular, coherence is linked to concepts like consistency, correctness, or predictability, which means that it is also linked to legal reasoning. However, it is not reduced to either consistency, correctness, or predictability, which means that it is an independent concept. Now, a second thing to pay attention to when discussing coherence is legal reasoning itself. Legal reasoning is, after all, the means through which lawyers argue about the existence and content of the law, including customary international law. And to determine the role that coherence has to play in legal reasoning, therefore, one needs to determine what kind of reasoning legal reasoning is. And my view would be that legal reasoning is practical rather than simply theoretical. And I will be very brief here, as I think we will hear more about the different types of reasoning in the interventions to come. So briefly, theoretical reasoning is reasoning principally about questions of fact, explanation, or prediction. It aims at the formation of a belief about what is or is not the case in reality. And here it's the classic deduction or induction example. And of course, the traditional understanding of legal reasoning is that of theoretical reasoning, in particular that of a logical deduction. By contrast, practical reasoning is reasoning about what to do when faced with a problematic situation. Practical reasoning does not stop when we form an opinion or a belief about what the case may be, like theoretical reasoning does, but it continues until we commit ourselves to a course of action given the problem that we're facing or the goal that we seek to achieve. In other words, attaches to a project that one has and seeks to identify the course of action that would lead to a satisfactory completion of that project. Practical reasoning seeks to help us decide what ought to be done or perhaps not done given the situation as it is or as we evaluate it to be. And in the process, the plan may be changed or amended, or the moves to achieve the plan may be rethought and redesigned, or perhaps new moves may have to be made without necessarily changing the existing ones, which also means that, like the concept of coherence itself, practical reasoning also manifests frequently as a web or a network. And I think legal reasoning is better viewed as practical, as I think it better corresponds to the way lawyers tend to argue and deliberate about the content of the law. And I also think that two remarks can follow from such a view about legal reasoning, which have a bearing on what I take to be the dual role of coherence in legal reasoning. A first remark is that by seeing legal reasoning as practical, this ultimately means that lawyers are a bit like researchers, just in a practical context. And this being the case, they have to do a couple of things like posit goals or intended plans, even if implicitly, and identify an area of practice based on that, which we may broadly call an act of framing. Another thing they have to do is they have to identify a system of knowledge that will help achieve that goal, which we could call contextualizing. And a third thing is that they have to work towards bringing those two into accord with one another, which we could describe as a process of exhibiting reflexivity in their practice. A second remark to make is that by seeing legal reasoning as practical, this further complements an understanding of coherence as being both substantive, which is to say a goal or an ideal towards which to strive, and methodological, which is to say a manner of working towards that goal. And now at long last, I come to the question of how the above may be made to relate to the interpretation of customary international law. And what I propose to do here is to sort of briefly build upon what I take to be a Dworkin-inspired understanding of customary international law interpretation, recently proposed in a European Journal of International Law article by Hassapis Tassinis. And he identifies 3 stages of customary international law interpretation. According to him, stage 1 is identifying the practice, the relevant materials of practice. Stage 2 is describing them at an appropriate level of abstraction in order to infer guiding norms. And stage 3 is determining the exact scope of a rule to be applied in the concrete case. Now, I would argue that each of these 3 stages broadly correspond to the processes of framing, contextualizing, and being reflexive, just identified as being closely related to coherence. I should also want to say here that I don't think these stages are probably as neatly distinct or distinguished in practice, but for purposes of presentation, I think we can distinguish them. And so on the first stage, identifying elements of practice implies a prior act of framing of the legal question that one seeks to answer or of the problematic situation that one seeks to resolve. And this is similar to the pre-baking idea that was mentioned yesterday by several panelists, and perhaps, or at least partly similar to the idea of the opinio juris double counting mentioned by Professor Westermann, if I understood it correctly. And framing in this sense is indispensable since practice can be virtually infinite. States engage in practice multiple times each day, and we cannot hope to isolate those elements of state practice that would be relevant for examination unless we have already framed with some degree of specificity a legal problem to resolve or a goal to achieve. As Professor Monica Hakimi recently remarked in an article, indeed, international actors do not approach customary international law as detached observers, but I should put it, they do so as advocates advancing their own preferences. And for example, if one wishes to make a case for a new and less strict content of the customary international law minimum standard of treatment of aliens in the context of foreign investment protection, one should focus on such practice as exemplified in the content of investment treaty provisions, or interventions made by states at UNCITRAL or UNCTAD, or positions taken by states in litigation or in non-disputing state party submissions, or any relevant diplomatic exchanges in the negotiation of investment treaties. A couple of other things are worth further noting here, and one of them is that one does not stop in the carving out of the appropriate area of state practice following the framing of the problem. The authority of different materials of practice is a matter of degree, as for example, the ILC's work on the identification of customary international law also indicates. For example, the ILC has indicated that practice of non-state actors has limited probative value compared to that of state actors. Furthermore, some materials of practice may only be prima facie relevant. Again, the ILC studies has indicated that state practice may carry more or less weight depending on whether it is inconsistent over time or whether it varies over time. A decision may have to be made, therefore, about the relative weight, authority, or priority of each identified material of practice. And it is perhaps here that the act of framing or the pre-baking of the issue at an appropriate level of abstraction may help to guide that determination. A second important thing to note here relates to institutional role. Different international actors have different institutional roles. And I think this is a point raised before by Professor Ulstein, which may affect, so different institutional roles may affect the kind of questions that each actor seeks to answer and the kind of legal problems that each actor seeks to resolve, in particular when making arguments about the content of customary international law. For instance, states generally enjoy greater freedom in devising policy goals to be pursued via legal means. And so they can generate arguments about possible customary international law norms or about new meanings to be assigned to existing norms from the ground up, simply by acting and rationalizing their actions and choices. By contrast, the institutional role of international adjudicators is more constrained. When determining the content of a customary international law, they can proceed acceptably only by attempting to reconstruct the intentions of those states that have put forward relevant practice and substantive arguments in relation to some norm of customary international law. Now, moving on to the second stage of customary international law interpretation identified by Hassapis-Tessinis, one has to describe the collected materials of practice at an appropriate level of abstraction so as to infer general norms from them. This, to my mind, implies an act of contextualization. This is necessary and, in fact, quite normal because facts in and of themselves do not lead to a normative conclusion in the absence of some background context. State practice being factual, essentially, similarly says nothing of normative value in the absence of context. In the interpretation of customary international law, contextualization means placing collected practice against a suitable normative framework, which is to say, placing it against an interpretive background that will assign meaning and significance to it. Contextualization, I think, can take place at various levels of abstraction. For instance, we could think about it taking place against broad areas of international law that already have existing norms and practices in them. And one could think of examples like the law on the use of force, or jurisdictional immunities, or the treatment of aliens abroad in the context of the protection of foreign investors. Or contextualization could also happen against more specific and already established norms or doctrines of international law, like self-defense, uti possidetis, or the minimum standard of treatment. A thing to note here is that the level of abstraction at which one describes practice normatively is important because it could determine whether one has identified enough evidence of practice or whether one must go back to look for more. And I think here it's the issue of head of state immunity before international criminal courts mentioned yesterday and earlier this morning, for example, in the al-Bashir case, could be a relevant example here. And lastly, moving on to the third stage of customary international law interpretation, which involves a determination of the exact scope of a concrete norm of customary international law to be applied in the particular situation. This is where I think active reflection becomes important, primarily for two reasons. Firstly, because determining the content of a concrete rule to be applied depends on the choices and moves made during the prior interpretive stages. Secondly, because this is the stage in the process where the actor actually commits. So whereas the actor's judgments in the former two stages are held tentatively, it is at this stage that the actor commits to a course of action that will hopefully resolve the original problem in a satisfactory manner. And again, the implication here is that there exists a back and forth relationship between the outcome and the steps leading to the outcome. And it's because the outcome and the steps need to fit well together, that one may have to go back and rethink the earlier steps in the process, or change one's mind about what the outcome should be. And again, this is not unlike being a researcher, only in the context of practice. Judgments at this third stage could be described as essentially axiological or substantive, which is to say, to my mind, they tend to rely on the rightness of the outcome because, for example, the outcome conforms to some generally recognized principle of justice, or because the outcome is compatible with the juridical aims and accepted practices of the particular contextual framework identified during the previous stage. And a last point to make very quickly, and with that I will conclude, is that legal techniques that may be used as the means to make such substantive judgments during this third stage include prominently analogies and analogical reasoning. Indeed, as Robert Kolb has written in the past, it is through analogical reasoning that one tends to establish a link between the is and ought in customary international law. And in this case, the is the observable state practice, and the ought is the actual rule of customary international law that one is applying. And with that remark, I should conclude, and I should thank you very much for your attention.
Thank you very much. I would like now to open the floor for questions about this paper. I'm looking at Q&A and I'm looking at the chats and checking whether I see any raised hands, but I don't think I see anything at the moment. Oh, Panos and Stephen Wheatley. Panos, you can go first, and I would say if Stephen then could also ask his questions, and then you can Charalampos can start answering them together.
Thank you, Freya, and thank you, Charalampos, for this very, very interesting presentation. The question that I had was, at the end, when you were dealing with the third stage, when you said that there we might have to go back again in the previous stages and the choices that were made in the previous stages, right? In the first two stages. Mm-hmm. My question there would be, how exactly do you envisage that? In the sense that I understand that in some situations that might be relevant. This ties also with Professor Westerman's presentation yesterday. But what happens in the case that you don't actually have any relevant state practice, so that there is no state practice, you know that? How would you go back then? Aren't you kind of stuck in the third one? Or do you mean that you would have, as you said, kind of revise the entire thing, that, oh, something's going wrong, there is no state practice, and that's the end of the conversation?
Mm-hmm.
Yeah, sorry. So first I'd say I really enjoyed this paper because we throw words like coherence around without thinking, and it really made me think. And so this question is really from a level of high ignorance. But it seems to me that your argument must be that coherence has a value. And trying to unpack what you were saying, it's not a moral value, it's a practical value. But then that value must be compete against other values. And I was wondering, what is the value of coherence? And yesterday we heard about the difference between effective control and overall control. Now in that, the move to overall control allowed you to capture people that had done morally reprehensible things. But coherence might direct you to effective control that would allow those people, and that is both a legal judgment, but it's also a moral judgment. So, I mean, am I correct in understanding coherence as a practical value? And then how do you weight that value against other competing values like ethics, human rights, blah, 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 blah. But anyway, I really enjoyed the presentation.
Charalampos, is it okay to answer these two questions, and then we can have another round? I think if you keep your answer brief, we can see whether there's some other questions. Panos, your hand is still up. Is that for a question in the next round? Or yes, okay. Charalampos, please go ahead.
Thank you for your, I should say, a bit difficult questions to answer. On Panos's question, I would envisage, I think I would go back to the idea of Professor Westerman's yesterday, that opinion juris is sort of double counted, and then you use it at the beginning. and then you use it at the end as a sort of filter. So I would say by sort of framing the question at the outset, you sort of carve out an area of practice that you're particularly interested in, and you look, and then from that you build on and you conceptualize. And at the end, again, it's opinio juris and the sort of your general understanding of the system and the general principles, and whether that conforms, that would make you go back and rearrange perhaps if you have to. So I don't think you could start by not having any practice. I take the point that there may be cases where courts, as we've heard yesterday as well, they do not seem to look for, when they pronounce norms, they don't find new practice or opinion juris, but I would take that as being an example of interpretation, and particularly where the way you describe practice at a level of abstraction at the beginning may sort of guide that point. And I think the example here could be, again, the al-Bashiri case that was mentioned. So as I understand the case, and again, coming in as an outsider, if you think that head of state immunity derives from a general principle of sovereign equality, then you don't necessarily need to go back and look for evidence of practice to justify a new rule of customary international law. And to move to the second question, how does coherence as a practical value versus a moral value? I think it can be both. I think acting as a goal, when one frames a legal question or a problem, one also frames it in the context of one's institutional role in the system. So in this sense, I think coherence can act as a moral value. As a practical value, it comes in the back and forth stage when one tests different possible avenues towards achieving the goal that one has originally set. And to sort of how it relates to other ethics, I think to some extent, ethics, as judicial ethics, are subsumed under a concept of coherence, because coherence is also about the way, as I see it at least, the way how international adjudicators should deliberate among them collectively, and sort of the moves that they take as a collective body. So I think I would subsume at least judicial ethics under a sort of account of coherence, so to speak.
All right. I see we have a question from Pauline Westerman. I don't see any other questions in the Q&A, but Pauline, go ahead.
No, it was not really a question, but tying to the discussion with Panos about the absence of state practice. I think there's never an absence of state practice, because you can always say, well, we have these texts, these resolutions, and so on, all these texts, and then we just call something state practice, and something else we call opinio juris. I mean, it's a matter of decision whether you put the name of state practice to some texts and not to others. So I would say there's never the absence of state practice, because there is always the possibility to take something from opinio juris and to put it in that source. That's what I have against this source kind of image. I don't believe in this, but that's what I said yesterday. So I will not remember. I think that is I'm not sure whether that would be acceptable to you, Mr. Giannakopoulos, to have this terrible deconstructivist conclusion.
I think throughout the years, I have learned to worry a bit less about these things and just go with the flow. But I hope I have understood your point about the opinion jurors double counting accurately. Yeah.
I think Panos would like to briefly intervene, and then I'm afraid it's best to conclude and go to the next paper. If we have some time at the end, then I'm happy to sort of get some questions about all papers, but I want to make sure that the other two presenters get the same half hour that Charalampos has gotten. But no, Panos, please go ahead.
It was just a clarification. When I said there is no state practice, probably I should have clarified this. I was going through the discussion that we had yesterday and today, that we have a rule that there is certain state practice, let's say for command responsibility or for IHL principles, but there is no specific state practice for this particular instance, like cyber operations or whether command responsibility. So that's why I was saying you would go back. But I do take the point there. So I was by no means saying there is no state practice whatsoever. I was just saying there is no specific state practice as to the particular situation that you're looking into. But Charalampos, you've already answered my question, so it was just more of a clarification here.
Okay.
Thank you, Panos. Charalampos, would you like sort of a final 30 seconds to wrap that up?
Just a final 30 seconds. Perhaps this is an area where analogy would do the trick, right? You don't have a specific rule on that particular fact pattern yet, but maybe they're similar enough that you could extend it by analogy. And that will be my quick response. Thank you.
Thank you very much. I think without further ado, we should now move on to Henrique Marcos, who's a PhD student at Maastricht University and the University of Sao Paulo, if I understand the biography correctly. He's also a researcher at the Center of Research in International Courts at the University of Sao Paulo, and he is about to present his paper entitled A Reason-Based Approach to Coherence in Customary International Law. Henrique, I can't see you for some reason. Are you there?
I'm here.
Oh, perfect. Okay, please go ahead.
All right. Okay, fantastic. Thank you. I'll try to share my screen. I just want to see if it's possible. Yeah, I believe so. Can you see my little presentation? Yeah. Okay. So first of all, let me just start my time here, just so I don't go beyond the 20 minutes. First of all, thank you to the organizers for actually accepting my paper. I'm very, very happy to be here. At first I thought that my paper would be a little bit outside the discussions, but now I see after the second day, the 2 days of conference, that actually we're discussing exactly the same thing. And Giannakopoulos, basically, we could have done our presentation together. Sometimes we have a little bit of I'm not sure we agree 100%, but perhaps we're 99.95% in agreement on everything. So I'm very happy to be here. And throughout the presentation, I'll mention a couple of other papers that were presented by other presenters. So, well, without further ado, as Professor Baetens said, my paper is a reason-based approach to coherence in customary international law. And in short, my argument is that still complexities or complexities related to customary international law are evidence that legal reasoning and the justification of legal arguments is not deductive syllogistic reasoning, because I believe that while deductive syllogistic reasoning ties coherence to lack of contradiction, legal reasoning allows coherence to find its way out of contradiction. So it's pretty much what Giannakopoulos was saying about consistency and coherence, the difference between the two. But I affirm that legal reasoning is logical reasoning, just not deductive syllogistic reasoning. In my opinion, legal reasoning is better modeled by what I will present as a reason-based logic. So in short, I want to just make another clarification point. We talk about reasoning, interpretation, and justification. I think that you could hear everything I'm gonna say and interpret it as interpretation, because I believe that if we adopted Dworkinian approach, where interpretation is something broader, reasoning is part of interpretation. But I will focus and I will use the word reasoning because I'm mostly focusing on personal or interpersonal, explicit or implicit cognitive process to reach an interpretation, as well as to justify an interpretation. So this is the structure of my presentation. We will begin with what is coherence, pretty similar to what Giannakopoulos mentioned. We'll go to still complexities, process and exceptions, coherence and deductive reasoning. Is deductive reasoning legal reasoning? Is legal reasoning logical reasoning? And then I'll say yes. And then I'll show which kind of reasoning I believe, which kind of legal reasoning is, which kind of logical reasoning is legal reasoning, better yet. So basically, as we already started to present, coherence is it's a big word, and we use it with very different meanings. I believe that we have at least 4 meanings that we generally use as when we talk about coherence in law. There's coherence as rule consistency or lack of conflicts. Coherence as uniform rule application. This is linked to predictability. Coherence as a anti-foundationalist theory. This would be an epistemic idea of coherentism. Coherentism as a web of beliefs or positions that are justified by each other instead of a pyramidal structure. And here I will mostly focus on the idea of coherence as intelligibility, rationality as making sense, as something being justified. Or if we use predicate logic terminology, we could say that coherence would be the same as validity. But I do believe these concepts are connected. I believe there is a family resemblance between them in a Wittgensteinian sense. So I think that they're not separate. So, well, this is basically the definition of coherence we're going to use, and now the still complexities. Notice that I'm going to use customary international law as a phenomenon, and this phenomenon will provide evidence that, in my opinion, legal reasoning is not deductive syllogistic reasoning. So I'll focus on 2 complexities. First, customary international law emerges from a set of facts practiced with 2 dimensions or gateways, as Westerman mentioned. But here I want to emphasize, and I'll repeat this further on in the presentation, I'm talking about facts in a very broad term. So I'm not talking facts as raw material facts. All facts, in my opinion, are, given that all facts are language-based, they're all facts depend on a certain conceptual theoretical framework. No, there are no raw facts in my view. So I don't adopt a absolute conception of the world. And I believe that Westerman would be in agreement with that. If not, we can discuss it in the end. But basically, we have 2 gateways, general repetition and opinion iuris. And here I will focus on general repetition. And because basically the idea is that there's a general practice, but this practice does not need to be absolute. The Court of Justice, International Court of Justice says virtual uniformity. So basically it suffices to say that the practice is generally uniform. Also, general conformity is acceptable if contradictory behavior is seen as a breach or exception. We'll also focus on exceptions. But I really need to emphasize what do I mean by an exception. Because generally we think of exceptions as use of force is unlawful, use of force in self-defense is not unlawful, and this would be an exception as a extraordinary case that goes against the ordinary. This is not my definition. There's no problem with this definition, but it's a terminological choice that I claim that an exception is when an applicable rule is not applied. So rule 3, use of force is unlawful. Rule 4, use of force in self-defense is not unlawful. The legal conclusion would be apply R4, do not apply R3. This would be the definition of exception for my purposes here. So, okay, in short, we have 2 complexities, and they present the idea that customary international law is flexible. It is tolerant to some deviation in the relationship between premises and conclusions. So preceding practice is general, not absolute, and sometimes there are exceptions. Okay, so the problem is that we use in our natural language, or even some people do believe that we're deducing. We talk about, oh, we will deduce or use a deductive process to realize if there is customary international law or not. This is not only, scholars not only say that, but also the ICJ says that, was unable to deduce. And we saw on the first day, on the second panel, a discussion between Westerman, Wheatley, and Worcester about whether if we were using deductive methods in international law and deductive methods in customary international law. There are also legal theoreticians as McCormick, which was mentioned by Giannakopoulos, who also says that legal justification is to some extent deductive. I'll argue that it's not, I don't believe that's the case, but basically what would be a deductive syllogistic kind of reasoning? It's basically a kind of logical argument that has 2 premises. There is a major premise, there's a minor premise, and there's a conclusion. So very simple example, birds can fly, Tweety is a bird, conclusion, Tweety can fly. If we try to adopt that to legal reasoning, we would sort of have something like this. We have a major premise, which would be a rule. And this rule, for example, use of force is unlawful. We have a minor premise, which would be the case. Mexico has used force against the US. And then we have a conclusion, legal consequence. Mexico's use of force is unlawful. This seems pretty attractive. And it is indeed attractive because if the premises are true and the rules of deductive logic are followed, it is necessarily true. The conclusion is necessarily true. But then we go back to the problem I mentioned. Customary international law has some deviation, and the standard for coherence for syllogistic reasoning is intolerant of deviations, inflexible. So we cannot model exceptions, we cannot model generality by means of a syllogistic deductive reasoning. If, for example, we think of exceptions, Under a deductivist model, if the civil rule is applicable to the case and the civil rule exists, then the conclusion must be that the civil rule's consequence must be attached to the case. If not, we would have to conclude that the rule is non-existent or is not applicable. But the problem is that exceptions do occur in practice, and exceptions do not warrant the conclusion that a rule is non-existent. If the rule was non-existent, there would be no exception to make in the end. So this is the problem I'm presenting. And from this difficulty to model syllogistic reasoning, deductive syllogistic reasoning, to legal reasoning, there's a conclusion that legal reasoning is not logical reasoning. So for example, in Talman's paper, which was even mentioned yesterday, the logic of judicial decisions is not the logic of syllogism, but rather the logic of law. All right, fantastic, I agree with you 100%. Logical reasoning is replaced by legal reasoning. There, I think we could better elaborate a little that last part. I do believe that legal reasoning is logical reasoning. If not, we would be admitting that it's illogical or senseless. But the problem is that it's not syllogistic deductive logic. So what logic would it be? And here comes my claim. I think that there's not a single logic. We generally have the idea that there's big logic, but it's not really the case. There are logics in plural. Susan Hack's book, Philosophy of Logics, mentions that very well. And a logic is basically a framework that allows us to structure reasoning and help us access the truth. So logic aims to structure and provide standards for evaluating the logical qualities of arguments. Logic does not solve our problems. This is also very important because it's a common criticism that legal logic receives, is that, oh, we're trying to solve the problems of the world with logic. No, it's not really the case. We're just trying to provide standards. So, and there are many, many kinds of logics, not only deductive syllogistic logic. Reason-based logic, which is the one I'll present right now at the next slide, gives the center stage to reasons, not to syllogisms. And why would reason-based logic be better than deductive logic? Because in my view, it better models legal reasoning compared to deductive syllogistic reasoning. It also allows us to structure arguments clearly, checking whether they are justified. And I think this is relevant to the discussions we had in this conference because, for example, on the second day, the panel that preceded this, we had a discussion by Yildiz and Yildiz on how if a court, it's not really clear if a court's reasoning on whether there is a custom or not is justified or if it's inconsistent. We also had, Ayub also mentioned our courts taking the rabbit out of the hat. I believe that the framework I'm presenting here could help us better see if this is indeed the case, if we're just taking rabbits out of the hat, or if indeed there is a justified structure to provide a framework for that argument. So basically, reason-based logic is focused on reasons. And what is a reason? Reason is our facts. Again, I'm using a very broad notion of facts. Facts is state of affairs, a very broad notion. So we could have like the fact that this building is a Baroque style building. This is a fact. It is a fact that this music was authored by Bach, etc., etc. So basically, a fact is a state of affairs that obtains, and it works as a truth maker. If I say it is raining in The Hague, that sentence would be false right now, because right now, at least from my window, it's not raining. But if perhaps in a couple of hours when it is raining, that sentence would be true because it corresponds to a state of affairs that obtains, i.e. that it is a fact that it is raining in The Hague. So this is my definition of facts. And a reason is basically a fact that leads for or against a conclusion, a pro or a con reason. So the fact that it is raining is a con reason for going to the beach. The fact that it is raining is a pro reason to bring an umbrella when going outside. So we have multiple kinds of reasons. I will not go into that, but we really are interested here in justifying reasons. And in a way, we're interested in motivating reasons in as far as we want to know if a motivating reason is also a justifying reason. So a very simple example. Should Henrique stay in bed until noon today? I have pro reasons. Today's a rainy day. I like to sleep when it's raining. Henrique's traveling tomorrow early, so I should get a lot of rest. My bed is very comfortable. These are pro reasons. The con reasons that I have undertaken to present a paper here at 10:45. So I have decided, balancing these reasons, I have decided to actually come here and present the paper. I could have done that implicitly or explicitly. But the point is that it's also similar to what Oitman mentioned in his presentation, the idea of equilibrium and practical concordance. When we reason with reasons, implicitly or explicitly, we're balancing opposite sets of reasons, and the outcome, the conclusion, is a decision on which set of reasons, pro or con, outweigh the other set. In the end, if we have time, I think that this also can help answer the question on whether coherence should supersede moral values or something else. We can also use coherence as a kind of reason for a certain decision. But basically, how would we adopt reasoning with reasons to rules? A rule would be applicable to a case. I think this is a safe assumption if it exists or if it's valid. For my purposes here, it's the same thing. And that case matches the rule's conditions. But the fact that a rule is applicable to a case is only one reason to apply that rule to a case. Sometimes we can apply a rule to a case even if that rule is not applicable. That would be analogy. And it's also possible to mention that the reasons for applying an applicable rule to a case can be outweighed by reasons for not applying an applicable rule. For example, in case of a conflict, in case we need to make an exception. And in this definition, an exception occurs when an applicable rule is for some reason not applied. All right, so we have this definition of exceptions, and I want to present you an example. State X uses force against state Y. State X claims it used force in self-defense. Let's assume state X is speaking the truth. Indeed, it used force in self-defense. So the applicable rule set would be use of force is unlawful, use of force in self-defense is not unlawful. And now we know that R3 and R4 are applicable. So now this is basically the calculus we have under reason-based logic to provide whether what decision would be justified. And this is the same thing, I'm just closer. So basically we have a case of use of force in self-defense. We have the first fact that R3 and R4 are applicable to the case. This would lead to a decision, D1 or D2. We can apply rules or not apply rules. We have a pro reason, which is a fact, F2, which says that the rules are applicable. So that's a pro reason for applying. The same fact works as a con reason for not applying. So we decide to apply it. We can apply both rules at the same time, or we can only apply one rule. If we compare the facts with the reasons here for each decision, we can see that applying both rules leads to conflict, and rule conflicts are undesirable. This is a con reason. So it's a con reason to apply both rules. So we decide to apply only one rule. So avoiding a rule conflict is desirable. This is a pro reason for applying only one rule. But now we have to decide which of the two rules we should apply, R3 or R4, which basically leads to the second part of the calculus, which basically we will compare reasons for applying each of the two rules. The fact that they're both applicable, that balances each other out, but there's the fact that R4 is lex specialis. So that's a con reason for applying R3, and it's a pro reason for applying R4. So we decide to apply R4 and make an exception for R3. Getting close to the end of the presentation already, now I just want to point out how that could also be used to explain the SIL process. We can think about the SIL process, or basically the process of a new customary international law rule surfacing. We can think of that as an application of an implicit and informal meter rule sourced in custom and Article 38 ICJ statute, which would regulate the recognition of the existence of a SIL rule. Notice that one thing is the custom, another is the meter rule that regulates how customary rules emerge, which can also be sourced in custom as well as Article 38. This would be a very simplistic formalization of the rule, which basically this is the name of the rule, SIL process meter rule. It's made out of two conditions. We could merge these two conditions, but I prefer to present them as such. Condition A, condition B, and consequence C. Basically, X is the variable. If we have general repeated practice of such and such by states, it's condition A. Condition B, belief that a practice of such and such is carried as a legal obligation. Consequence C, practice of such and such is a rule. So the process of recognizing the existence of a SIL rule would be an application of this meter rule to an applicable case. And in sum, my argument is that SIL rules are rule-based rules, a rule that surfaces from the application of another rule, the SIL process meter rule, which itself is a basic social meter rule. All right, how would that work? And basically, can we provide some illustration to that? Again, I'll return to this example of the customary rule prohibiting the use of force. Let's call this rule the prohibited force rule. There's a repeated practice of not usage of force. The practice of non-usage of force is carried out as an obligation. And then we see that the conditions for applying the SIL process meter rule to the case are met. So it's applicable. The fact that it's applicable is a reason to apply it. If after rebalanced reasons, we apply this meter rule to the case, it will turn the practice of not using force into a rule into the prohibited force rule. Or, which I believe is even better, SIL process meter rule will retroactively recognize that prohibited force rule exists as a rule in a certain setting. So if we apply it, it recognizes that it existed, and that can have retroactive force. Okay, but when I began, I said our main problem here is the general practice complexity, was that sometimes they're both conforming and non-conforming practice. So it becomes a matter of reasoning whether condition AX was met, i.e. if conforming practice was indeed general. This is the calculus to provide that. If we have a SIL meter rule applicable to this case, a rule is applicable if it's valid and conditions are met. So let's assume it's valid. Let's assume the case matches condition B, which is the opinion juris. We could also further develop these two, but just to make the explanation easier. And now we have the problem. Does case match condition AX, which is the general repeated practice? We have con reasons for that decision, but I believe we have more pro reasons. So let's assume we decide that, yes, indeed, case matches condition AX. But here's the point, and I want to emphasize. These are not raw facts, again. And we could also breach out. For instance, we can have an argument on whether fact 7, which is a pro-conforming practice, is indeed a pro-conforming practice, if indeed it is a practice, if this practice is a practice of a certain custom or not. So this could branch out. This is not axiomatic. So, but let's assume decision 2, case matches condition AX. So now we have the 3 elements. So it's valid, condition A has been matched, case matches condition A, case matches condition B. Now this leads us to fact 13, which is the sole process meter rule is applicable to the case. If we decide to apply it, the fact that the sole process meter rule is applicable to a case, the reason to apply it. If we decide to apply it, it will recognize the prohibited use of force rule as a customary rule of law, and it can do that retroactively. Well, basically, this was my presentation. I thank you very much for your attention, and I'll give the floor back to Professor Baetens.
Thank you very much. We have a couple of minutes for questions, and Q&A seems empty. I think Andreas Follersdal has posted 2 questions. Andreas, would you like to present your own questions, or shall I read them out?
Well, they're not really questions, so they're more requests for more information. So it's not. I don't think it's worth.
You don't want to ask them? Okay. Anyone else?
Panos.
Sorry, for some reason I can only see the presentation. I cannot see any raised hands or any. Yes, sorry, Panos and Pauline. Yes, great. Please go ahead first. I think Panos was first, and then Pauline.
Pauline was first. For some reason, my name appears twice. I don't know why. I was planning on raising that, but Pauline, go ahead.
Well, I would say that you count double, Panos, not only opinio juris. Of course, I'm very glad with all these caveats about I'm not referring to raw facts, etc. I'm so glad that we don't listen anymore to people starting to talk about raw facts and instead of reasons. So my question would a little bit be like Andreas's question. Because reasons as such, do you differentiate between kinds of reasons? Do you differentiate between, in the same sense as this reflective equilibrium kind of thing, like was Rawls's idea about intuitions and about well, deductions from general principles? Or is it for you just enough to say, well, reason-based, this is the way to look at it, and I don't differentiate anymore? So it is a little bit similar, and I think that there's a real question there in this too modest approach by Andreas to say, well, it's only a remark, but there is a real question hidden there.
Okay, Panos, do you want to? Is your question linked, or shall we give an opportunity to respond first to Henrique?
Yeah, my question is on a different topic. The other Panos is Nina, who decided to use my name.
Okay, well, since Panos's question is on a different topic, Henrique, would you first like to respond to Pauline's question?
Sure. Okay, thank you for the question, and thank you, Andreas, for the comments. Well, I do believe there are, well, first I'll try to begin with Andreas. I think there are many kinds of coherentist approaches to decision-making, especially in practical reasoning, even if sometimes coherence isn't mentioned by name. So for example, Rawls' reflective equilibrium is indeed one of them. There's also Raz, who works with reasons, but now already linking to Westerman's question, what kind of reasons I use, I think that there's an ongoing discussion on analytic philosophy on whether reasons are psychological states, on whether reasons are beliefs, or whether they're facts. And for example, there's in my opinion, there's an ongoing discussion between Raz and a lot of the philosophers if what would be the ontological nature of reasons. My approach would be closer to Alvarez, which is a neo-Davidsonian approach, which takes that reasons are facts. So if I take an umbrella with me, I take an umbrella not because I believe that it is raining, I take an umbrella because it is raining. If it's not raining, I acted without a reason, but I can have acted through an apparent reason. So this is closer to Alvarez's approach, which basically all reasons are facts. And we could have different kinds of reasons. As obviously, we could have justifying reasons, motivating reasons, and explanatory reasons that she mentions. And the same fact could work as both an explanatory reason. It could also work as a justifying reason. As it could also work as a explanatory reason. I even had an example which I actually cut it out from the presentation, but basically I just read it here. Suppose John's coach tells John that John needs to train more so he can run fast enough to qualify for the Olympics. So the fact that John will only qualify for the Olympics if he trains more to run fast enough is used by John's coach to justify why John ought to train more. It motivates John to train more instead of watching Netflix, and it can also be used by John to explain to his wife why they cannot go to vacation. But in any case, I think that these kinds of reasons are more linked to the role reasons play, whether they're ontological status. I would claim that they're all facts. And I believe I'm not sure if I answered your question with that.
Could you live with? Oh.
No, I was thinking because it doesn't matter for you where they come from, the reasons. I mean, the kind of source-based theory in international law, then you think, oh, but they come from this source, or they come from general principles, like what Craig Agnett's contribution yesterday. So they are very much thinking all the time, where do they come from? That's what this source thing is meant for. Do you think that is important in order to differentiate between reasons? So I don't talk about the function of reasons, like what you do with motivating, etc. But the source they spring. Do you think it's important to delineate the sources that the reasons originate, from which the sources originate? Sorry, that's a bit early in my head.
No, yeah, I think I understand. Yeah, I think so. I believe that if we take if you consider legal argumentation as a language game, we would have specific rules for this game. And these rules would inform what kind of facts, or in this case, what kind of reasons would be relevant. So if I'm a judge and I decide something, and when I'm justifying it, I justify it based on reasons that are not sourced in acceptable sources. I'd say, for instance, oh, I've decided this way because I'm lazy, or something like that. This is the easiest decision. I think that would not be seen as a justified reason, and an argument could breach out. So if I present a reason which is not sourced in a formal source of international law, for example, an argument could be made that, well, that's not an acceptable reason, that's not a justified reason, or as some people say, it's not a good reason. And then we could have another argument which would go on a meta level on whether that reason is indeed a good reason. And even
sorry to interrupt you, but would that say it is not a good reason, or would that say it is not a reason? It doesn't count as a reason. Yeah,
that's also there is also that discussion. I prefer to say it's not a reason, but some people do say it's not a good reason. I believe you just say it's not a reason, as Alvarez does herself.
So then you would say it doesn't count also as a fact, because it's not a reason, it's also not a fact.
No, it would be a fact, but not all facts are reasons. So, for example, right?
I will leave you here, yeah.
For example, the fact that it is raining is not a good reason, or it's not a reason for me not to come to the presentation, given it's online. It's a fact, but it's not a reason for this decision process.
Okay. Thank you for your answer.
I have two questions, one from Panos and one from Nina presenting as Panos. If I may ask both of you to very briefly state your question, then you both, then Henrique has an opportunity to very briefly respond to both of you. Panos, the real one.
Yeah, the real Slim Shady, please stand up. So Henrique, thank you very much for this presentation. I'll need more time to, look into the diagrams and, make sure that I understood them correctly. And maybe this is the reason for my question is, in the last diagram, you kind of indicated that you have this CIL meta rule. And then you broke that to, widespread representative practice and opinio juris, and from that you came to a conclusion of whether a rule applies or not. My question, again, I might have missed this, is do you see any role or any branching out there with respect to what we've been discussing about, teleological considerations, systemic considerations? Do they come into play at all, or it's just those are enough?
Oh, may I answer already? But
yes. Oh no, sorry. Wait. Nina, if you can briefly ask yours as well.
Yes, thank you. And I'm very sorry that. Can you hear me?
Yes.
Yeah, I'm very sorry for the confusion with me logging in as Panos 2.0. Henrique, thank you very much for your presentation. For me, it was both very interesting and very complex. So my question goes to your early part of the presentation, just for a clarification. You explained to us that you essentially treat exceptions as a separate rule rather than a part of the original rule. So you said you treat prohibition on the use of force as one rule, and then the allowance to use force in self-defense as another rule. And I was just curious if you can explain a little bit more why. So how does this play into your understanding, and why it is not rather that we have one rule, which is states are not allowed to use force unless they are doing so in self-defense. So kind of this, I'm curious why you treat exceptions in the way that you do in your scheme.
Thank you. So Henrique, you have 1 minute to respond.
All right, I'll use my slides to help me. Just if we go back to this slide, which was Panos' question, basically their conclusion is that the rule is applicable to the case, and this is a reason to apply it. Remember that I'm not using a deductivist model. So the fact that a rule is applicable, the fact that a rule is applicable is only one reason to apply it. We could also work with teleological reasons for applying or for not applying that rule, purpose, equity, coherence, or whatever else. These also play as reasons that could be con reasons or pro reasons for applying that rule. So yes, I think that everything that you mentioned do play a role there. And now if we go to Nina's question, if I'm not wrong, this is a common deductivist retort. I even had this on the appendix because I already expected this question. Basically, deductivists say that we could work with hidden rule conditions. So exceptions are not just hidden rule conditions. We could rearrange the rule, which is basically what you mentioned. Use of force is unlawful unless the use of force is performed in self-defense, then deductivism could work. The problem is that it ignores the procedural dimension of legal practice. So agent 1 would plead for rule 1, which be use of force is unlawful, and agent 2 would plead for against rule 1, favoring rule 2, which is use of force is not unlawful in self-defense. So if we assume that it's just a single rule, we're ignoring the procedural aspect. This is complicated to model legal arguments. And second, it burns the legal agent with also an almost impossible task, which is basically we would need to determine every single condition of a rule if we knew precisely to what cases a rule can or cannot be applied. But we can also only know to which cases the rule can apply if we already knew all the hidden rule conditions. So it would be a bit paradoxical. Given that I don't really have that much time, I recommend you to read a paper by Jaap Hage and Antonia Walterman and Gustavo Rosemena called Exceptions in International Law, which adopts a very similar approach to mine, given that two of them are my supervisors. So yeah. So back to Baetens.
Back to Baetens, okay. Here we go. We're straight to the last speaker. Thank you very much, Henrique, for being so succinct in your last answers, by the way. We go to the last speaker of this panel. Harlan Cohen is the Gabriel M. Wilner / UGA Foundation Professor in International Law and faculty co-director of the Dean Rusk International Law Center at the University of Georgia School of Law. And he will present his paper entitled very succinctly, The Court Custom Paradox. Harlan, are you there? Yes, you are.
Thank you, Freya. And let me just start by saying thank you to Panos, the whole TRICI-Law team, and particularly to Marina, who not just for pulling this all together, but for, of course, if other people have said, for pivoting so quickly and elegantly, and for holding all of our hands during this process. I've been watching this project from afar for a while now, admiringly, and I'm really honored and thrilled to be able to be a small part of it. At the very least, I hope this provides a start to many more conversations with all of you going forward. I also just want to thank the co-sponsors Pluricourts here. It's always a special pleasure to be able to collaborate in any way with Andreas and Geir, so thank you. The other thing I'll just mention at the outset here is it's very early here in Georgia. It's 6:05 right now, which may seem like a perfectly normal time, but this panel started at 4:45. So the one thing I hope here is that if my thinking seems muddled, you'll just chalk it up to the hour and not the much more likely reason, which is that my thinking is muddled. Okay, so on to the topic for today. So we're talking about coherence, custom, and international courts. And I would suggest that coherence, custom, and international courts presents itself as a puzzle largely at the surface level of international law, a question about the outputs, products of the complicated interlocking machinery of sources institutions. It presents as a challenge for trained international law technicians, a matter of tweaking these gears, pulling those levers, monitoring these levels. I think the puzzle, though, runs much deeper, that the questions posed to courts by custom and coherence reveal foundational questions about the interoperability of international law sources, the ways different sources of international law have been coded in different formats, and the ways moving between them always requires processes not of integration, but translation. For international courts, I'll suggest the result is a paradox. Coherence presents as a fragmented choice between the coherence of customary international law, the coherence of the court's own jurisprudence, and the coherence of international law doctrine. Coherence across all three will often be impossible. Getting to that conclusion, though, requires a return to, and I would suggest a reconstruction of, international law sources. Now, usually we hold the forms we've been given in Article 38 of the ICJ statute, custom, treaty, general principles, constant, and ask when, why we're using different forms of justification, right? This is the familiar debates we have over, say, traditional custom and modern custom. I want to flip this on its head, though, and suggest that hiding behind the labels, right, treaty, custom, general principles, are actually different sources with different justifications and logics, different sources that may in turn be fueling disparate approaches to interpretation. In other words, within what we're calling customary international law, we may actually be talking about multiple distinct sources with their own operating logics. So to understand the problem, I want to start not with the formal sources we've inherited from Article 38, but instead with sources of legitimacy, with justifications for sources of normative authority. Why would any proposed source of international law be worthy of legal authority in the first place? What would our list of sources look like if we started not with form, but with justification? Here, I'm gonna share my screen, or at least attempt to. So I would suggest, if we grouped rules by how we justify them, we would see different categories, different sources that cut across traditional forms. Key, as I'll explain, in each category, each model of rules, each source, logic and justification suggest particular types of rules with particular features and forms, particular values to prioritize, and particular conceptions of coherence. The type of justification we start with dictates the answers to a range of other questions we might have about the rules emanating from them. Now, I'll focus on three right here, right? Negotiated law, legislated law, and adjudicated law. But if we look at this more broadly, in all honesty, we would want to include natural law justifications as well. I figured all of this is radical enough that we don't need to be getting into debates over natural law as well. But for our purposes, I'll stick with these three categories of justification within kind of the positive law tradition. Okay, so we can start with negotiated law. Negotiated law, as a model, imagines itself as the product of settlements hashed out over time. It derives its purported authority from notions of consent, autonomy, pragmatism, and the lessons of experience. These are hard-fought rules, and the rules are seen as good in this logic because they've stood the test of practice in the rough and tumble of international relations. Right? This model celebrates flexibility and a commitment to collaborative problem solving. Key here, negotiation shouldn't be taken as a mere kind of kumbaya friendly discussion, but would include jawboning, even outright conflict. The point is that the outcomes here reflect a kind of settlement and acceptance by the parties of the rules going forward. The ideal type here should call to mind traditional descriptions of customary international laws: two factors, practice and opinio juris, and the ways practice can slowly over time produce settlement over rules. But it also describes traditional bilateral treaty agreements whose legitimacy emanates from the particulars of the negotiated deal. But that's not the only way we justify international law rules. Sometimes we adopt explanations for both customary international law and treaties that sound more like legislation. Here, consent is again the normative justification, but it's a general or common consent rather than specific consent. The model imagines a rule being propounded, proposed, and then accepted by some proportion of the community, whether by affirmative acts or by common silent acceptance. Rather than the iterative, open-ended process of acceptance reflected by negotiated law, this model assumes a moment in which a rule with particular elements is proffered, a moment or a series of moments in which affirmation is collected. The best examples here might be International Law Commission products, both treaties and customary international law. You might think here on the one hand of the Vienna Convention on the Law of Treaties or the Articles of State Responsibility, but you should also think here of the Vienna Convention on the Law of Treaties both as treaty and as custom, right? You could also think here about universalizing treaty projects like the Genocide Convention. Neha's reference yesterday to the ICTY's treatment of the Rome Statute, even before it had come into force, might be another example of this kind of logic or justification in play. The value here are common starting points, collective, predictable guidance, and rules to build on. Finally, we have a model of adjudicated law. This law is produced through judicial or judicial-like decision-making. It derives its authority from implicit or explicit delegation, the authority of the decision maker, the power of reasoned exposition, and neutral, even-handed consideration. In contrast to negotiated law, which emphasizes values like pragmatism, open-endedness, and continued negotiation, adjudicated law emphasizes finality and justice, right? We often gloss over these, but in many ways, the move to courts, first at the turn of the 20th century and then at points since, is a belief in the capacity of neutral third-party expert dispute resolution that doesn't rely on jawboning and power. This is the hope associated with the shift of permanent courts and away from, say, ad hoc arbitration by the Tsar of Russia. Examples here include regime-specific precedents and rules for adjudication that might not emerge in raw state practice. Again, Neha's examples of mens rea or defenses in international criminal law fit in most obviously here, as she said, kind of precedent turtles all the way down. Or to put it another way, in negotiated law, authority flows from the collective results of innumerable dyads of negotiating actors who come to settle on particular rules. In legislated law, authority flows from common collective will. In adjudicated law, authority flows from the judge or from the court. Stop sharing, go back to the. Now, it's to be clear, these are not hermetically sealed categories. For one, for any customary international law or treaty rule, there's going to be disagreement over the category they belong in, reflected in types of justifications used. Such disagreements may even help to explain some of the most difficult, intractable fights we have over rules. Take fights over, say, the unwilling or unable standard for self-defense against non-state actors. Those supporting such a rule often draw from the negotiated law model, arguing that the rules must pragmatically respond to reality and focus on the rules being hashed out by those taking these actions. For those opposed to the rule, the argument seems derived more from kind of a legislated law model. They question whether or not the unwilling or unable standard is what was agreed on, or whether now, having been proffered, sufficient states have accepted it. Others still will focus on kind of an adjudicated law model and will look at the ICJ's reasoned articulation of customary international law of self-defense. Immunity, something that a number of people have mentioned over the course of the past 2 days, would also present another good example here, with disagreements being fueled by competing models of where those rules are to come from, right? Should they come from state practice, which might suggest one set of rules, some legislative moment like Nuremberg, or reasoning from broader principles of international law, as some international courts have done. But aside from disagreements about categorization and source, rules also transit between these categories. right? So a rule developed through negotiated law may be re-articulated as a form of legislated law. Think, for example, here again of International Law Commission products, but also think here about how the ways in which customary international law is applied to newly independent states in this kind of take it or leave it sort of way. There's no jawboning for them, right? They just have to take the legislation as if it came to them that way. Alternatively, right, customary international law rules developed through adjudication can be an input into the process of negotiation. I unfortunately missed Ezgi and Omit's presentation earlier today. That was really early here, or really late, depending on how you think about it. But having seen their work before on this, I think this is where you might sort of bring their work in as well. Now, custom can come in all three forms, right? You might think here very roughly, I think these are bad proxies of traditional custom, modern custom, and say common law, even as these categories at the same time blur some of the distinctions between custom and treaty. Okay, so what about interpretation and coherence? Right, so all three involve interpretation, but interpretation is going to look different depending on the model you're in. The most noticeable is going to be the contrast here between negotiated law and the other two. In the negotiated law model, interpretation is inherently tentative and iterative, right? Every interpretation is both a form of second person thinking. What do others think the rule is? What aspects of object and purpose, ordinary meaning, context do others think take priority, but also first person assertion, a proffer of a desired interpretation, right? Interpretation is part of an ongoing process, not the end of one. At the same time, while the other two focus on interpreting what the rule requires, interpretation in negotiated law is often as much about identifying the gap, the negative space, the room for continued battle or negotiation, right? Being subject to multiple interpretations is a feature of negotiated law, not a bug, at least in hard cases. Okay, I'm gonna share again here. So what about coherence? Drawing on different understandings of the law's function and purpose, different justifications of law's normative authority, coherence means different things, emphasizes different values, different types of predictability. Going in the opposite order from where we went before, for adjudicated law, coherence often involves what we might call courtroom coherence, right? The predictability of treating like cases alike, of knowing that the same rules will apply to different litigants. This obviously has important implications for international criminal law with presumptions like the legality principle out there. This is an outgrowth of the model's emphasis on legitimacy of reasoning and expertise. Both of these would be undercut if rules were interpreted differently in each case, as well as the model's emphasis on justice and the binary choices it faces, of right or wrong, winner or loser. For legislated law, coherence involves doctrinal coherence, right? This comes from kind of trans-substantive, transform predictability, common rules for all accepted by all. The idea with legislated law is to avoid the uncertainty of negotiated law, as well as the ex post justice of adjudicated law, by creating clear frameworks for action that can be interpreted in common ways with as little friction between them as possible, right? Values here, this values coordination over conflict, settled rules over settlement. Fragmentation undercuts these goals and may even be seen as illegitimate. Some of the appeals to uniformity in human rights law mentioned yesterday by Silviana might fit here. For negotiated law, coherence is a little different. Coherence is going to be something more like negotiation table coherence. It comes from the predictability of negotiating space, the ability to predict what has and has not yet been worked out, the space for experimentation and for jawboning. A court shouldn't be able to, under this model, like an interloper, stick its nose into ongoing negotiations, which in this model are all the time and endemic, and throw things in favor of one side or the other. Okay, so what should a court do? Now, despite the title of adjudicated law, international courts interpreting customary international law actually need to choose between these different models of coherence. We can see this problem in the WTO's dispute settlement understanding. While this is largely a matter of treaty interpretation, the problem is basically the same, right? So DSU 3.2 says, quote, the dispute settlement system of the WTO is a central element in providing security and predictability to the multilateral trading system. The members recognize that it serves to preserve the rights and obligations of the members under the covered agreements and to clarify the existing provisions of those agreements in accordance with customary rules of interpretation of public international law. Recommendations and rulings of the DSB cannot add to or diminish the rights and obligations provided in the covered agreement. So in other words, stick to the negotiated agreement and only those agreements, but provide security and predictability. This becomes a justification for precedent, all while taking into account customary rules of interpretation of public international law, which, by the way, might require looking at other external agreements and general international law, right? Yeah, try that. The impossibility and incompatibility of doing all of this is evident in the appellate body's attempts to interpret rules regarding anti-dumping and zeroing, where the appellate body, may its memory be a blessing, seeking courtroom predictability, adopted something like a doctrine of precedent, policed by a cogent reason standard. Simple, the appellate body thought, right? We'll apply the same zeroing rules regardless of the plaintiff and regardless of the defendant, though the defendant is always the US. For its efforts, the US declared war on the appellate body, drawing on the negotiated law model to argue that zeroing was a gap in the agreements purposely left for future negotiation and explicitly questioning the appellate body's authority to fill it. Or to put it another way, think about necessity, right? It might be valuable for international law to have a common definition of necessity, but looking for one where it would require a specialized court to look beyond its specific mandate would risk overturning its prior decisions and would undercut the process of state practice. Or take another example, fair and equitable treatment in investment law. And this is going to be vastly oversimplified because in all of these cases, it's a treaty overlay or multiple treaty overlays. But if you imagine kind of an arbitral panel looking at least at the customary international law question of FET, right? The question before it is a set of choices, right? If you want to be true to the negotiated law model and draw on it to justify your decision, right, to say that what all you're doing is sort of recognizing what's been hashed out by states, you would adopt a minimalist view of your role and of precedent. You would see interpretations as mere proffers, and you would be super attentive to the state's responses to those decisions, including attempts to renegotiate bits in the shadow of your decisions. This, though, would come at the cost of doctrinal coherence or courtroom coherence. If you're worried most about your authority as a court-like tribunal, right, and courtroom coherence, you might strive to treat like cases alike and stick at least to your own precedent. We know people choose arbitrators based on what they've done before, but that would be at the cost of both systemic integration and negotiating space. If you're worried about systemic or doctrinal coherence, you might eschew consistency of your own opinions in favor of looking to jurisprudence constante or Biaki or even beyond to foster systemic integration by looking to rules about the environment, human rights, sovereignty, right? Here you wouldn't be able to rely on negotiated law basis of legitimacy or delegated authority. Instead, you would have to rely on the authority of the international community as a whole. In a sense, this would be consistent with something like the legislated model, right? Sort of proffering a rule for all to accept or not. You get systemic integration, but at the cost of treating like cases alike, respecting specific negotiated deals and respecting space for future deals. Now, different courts will take different views on what sort of coherence they're trying to achieve based on what sorts of justification they're applying, right? Courtroom coherence may have a special place in international criminal law. The ICJ might care more about systemic issues. Arbitration, ironically perhaps, because that's not necessarily always the case, might want to leave more gaps open because of its particular role. But these decisions are always contested and contestable. And key, they aren't just decisions about coherence, but choices of justification, right? As William and others noted yesterday, courts aren't often crisp about this, right? They elide their choices, treating different sources and justifications as a sort of grab bag, mixing and matching models as needed. But critics often do pick up on this and will challenge decision on these bases. They will recognize the ways in which these various justifications and sources don't match. Now, this isn't meant to suggest that coherence isn't worth the effort or shouldn't be the goal, but instead that in our horizontal plural system of law, in which different sources of normative authority are allowed, maybe even encouraged, to coexist and compete, coherence will often represent a careful dance between these different ideas of international law. Perhaps strategically, we have decided it's better if we can justify rules through multiple sources of authority rather than just one. International actors can accept a rule as legitimate for different reasons. We often treat this as kind of a belt and suspenders approach. If we can justify something as a result of negotiation or as common acceptance or based on reason elaboration, all the better to make sure that everyone's on board no matter which model we accept. But the reality is that these normative systems will at points conflict, suggesting logics and values that dictate different interpretations of particular rules. The challenge that international law and international adjudication in particular has accepted is negotiating and navigating rather than resolving those differences. In other words, coherence in the interpretation of customary international law is a process, not an outcome. And with that, I will leave things for questions and further conversation. Thank you to everyone.
Thank you very much. We have about 5 minutes left, I believe, bearing in mind we started a bit later as well. And I see one question in the chat box from Andreas Follersdal saying that the account of sources and their possible justification seems promising. A minor issue of taxonomy, how should we think about and classify legal norms that some states claim that they do not only consent to, but rather recognize as already legally binding? Pacta sunt servanda might be one of several principles. Harlan, hold your horses for 1 second. I'm also going to ask Pauline Westerman whether she could add her question to that, because I think then if you respond to these two, I think that will be it for our Pauline?
Yeah, just a very short question. Why do you call it sources? I think it's very good to point out there are different contexts, or are they categories? So what is it? Context or categories? I think that the word sources confuses me as someone who's not a lawyer.
Thank you very much. I don't see any other questions at this point, so Harlan, go ahead.
So I think that it's a great question. And I mean, at some level, it may be that we're playing with terms in ways that may only confuse, and I don't want to do that, right? We all have set ideas about what these terms mean, and when we mix and match them, we may cause problems here. But I do specifically want to use the term sources here, because I think what's happened, and this is where it gets a little bit radical, right, is we're referring to various forms we have as sources, but they're not actually sources, right? What we want to know when we ask what a source is where does this particular rule get its justification for authority from? And here I think that the actual forms we have don't tell us that, right? They tell us a particular form that a rule might take. In fact, I think with customary international law, we often use it as kind of a catch-all for all things that are kind of unwritten, right? Well, if we really want to know the source, we have to be asking, right, what gives it its authority? And that's where I hope that this kind of taxonomy might help. But again, I don't want to get hung up on terms. It's more, can conceptualizing things this way help us to understand kind of the chain between authority, justification, and eventually going to things like interpretation and coherence. To Andreas's point, right, I think there are different ways that we can categorize this. You could categorize a rule like pacta sunt servanda here as something like the legislated law model, right? In the sense that the idea here is that this is something that the idea, right, idealized, is that at some point this was proffered and everybody kind of accepted it. But this is also where I think if we wanted to really complicate things, you'd want to bring in, as I said, these natural law justifications. It may very well be that for many, right, something like pacta sunt servanda has kind of a pre-legal existence. This is where you might look at kind of Fullerian type explanations. But it may be that for some, that's the justification or source for that kind of authority.
All right, on my computer it's just 12. Oh, Panos, no. Okay, Panos, you can have the last one. I thought we'd just make it within our hour and a half, just not. Panos, go ahead.
Sorry, my apologies for that. I was just waiting to hear Harlan's responses. Harlan, thank you very much for this very, very, very rich presentation. My question is, because you mentioned, you know, the let's say the codificatory, if we can say that, instruments like VCLT and so on. And since you mentioned the WTO and the dispute settlement bodies there, do you think that sometimes these codificatory instruments are used as a kind of a justificatory shortcut And how do you think this truly affects coherence or not?
So I think they are used as a shortcut. But the question is then figuring out, in the move to use them as a shortcut, right, what is the actual justification, right? Because it can't just be that justification is, well, there's this thing over here that we're referring to. It must be something deeper than that. So my suggestion here is that when courts refer to something like the VCLT as that shortcut, what they're basically saying is, here is something that everyone has accepted, right? We're basically taking that as kind of a legislated moment. And this is true whether it's the VCLT as treaty or VCLT as custom. We're basically saying we can look back to this moment as something you all accept, right? This is kind of a fixed point, and from that we can work. So the justification here isn't the VCLT. The justification is common acceptance.
All right. Then I would like to suggest, oh no, Andreas Fallada said everyone kind of accepted seems too imprecise. I don't know, Harlan, what do you?
I mean, it might be too imprecise, but I think that's the imprecise form that our argumentation takes, right? I think this may go to the fact that we argue in imprecise ways rather than the fact that it is imprecise in itself.
Yes, the failure of language to correctly translate thought. Okay, right. So I would like to thank all three of you very much for these interesting and thought-provoking presentations. I've very much enjoyed our two-day conferences and all the debates and discussions. And I think this will conclude this panel. And I'd like now to hand over to whoever is going to be in charge of the discussion and closing of the conference. And already have a nice weekend, everyone.
Thank you.
Pauline has just mentioned that I think that after all this panel generates more coherence than I anticipated. So on that very, very hopeful note, I think that this panel closes. So in the program we had allocated some time for discussion and closing remarks. This would have worked much better in a live kind of setting. But I think if the co-organizers, Pauline, Andreas, Geir, Marina, and Kostya agree, we can suggest that if anybody has, for any of the presentations that were presented during these days, any topic that they want to raise now, to raise their hands or mention in the chat. Otherwise, we can, it's been a long 2 days with very rich, very interesting presentations, very interactive, and we thank you all for that. But then if there are no further questions, I think then we can, Andreas.
So this was more a response to your prompting, Panos. So I thought the presentations and the discussions were very helpful, and as Pauline also mentions in the chat, there are more synergies. There's more connection here than perhaps was visible in the beginning. But I think so. We've learned a lot, and we've got, as Panos says, many inputs for further reflection, which is great, and Zoom can do that. What Zoom cannot do is the sort of more in-depth following up of the different arguments. Some of facilitate the sort of precision that we'd all want to. So I think, at least speaking for myself, I find myself at several times during the discussions thinking, oh, it would be great to have another half hour to focus in on that particular insight or that particular paragraph or that paper, how these two papers speak to each other. And I suspect that each of us might have similar views, but with slightly different clusters of papers, perhaps, reflecting our different interests and specialities. And so I would at least suggest that we think about possibly repeating some of these discussions, but with smaller groups, looking at ways of actually physically meeting or having more protracted modes of exchanges. Aiming again, of course, for publication. Perhaps some papers might be suitably clustered as a special issue of a journal, or perhaps they are better placed in different journals, different books. even after those discussions. But to repeat this, but perhaps in smaller groups, might be helpful. And again, some of us have gotten benefits from people referencing other people's works. So perhaps those larger groups could also meet together. It's some, at least virtually, but hopefully also in person.
Thank you, Andreas. I don't see anybody else. I think nobody would actually object to continuing this conversation, either in small clusters. And I think, as you rightly pointed out, Andreas, in many of the papers, we saw common themes, common threads, and even the speakers themselves usually ended up referring one to another, which was a very nice outcome for this conference. And I think, as I said, we saw a variety of issues. So whether it was interpretation in specific courts and tribunals, whether it was about using physics and mathematics and logic in understanding customary international law, philosophy as well, and also, of course, talking more generally about this whole idea of coherence. So there were patterns emerging, but I think the overall theme of that customary international law and its interpretation still remains a topic that deserves attention and more analysis, I think, shown through throughout the whole days. I don't want to, again, be the only one speaking. Pauline, Marina, Geir, if you want to add anything. Pauline is thinking about it.
I already said enough these days, so I'll keep silent for a while.
Geir?
Yeah, it just struck me that this is a very rich area and possibly even richer than I thought before the conference. So I think really that there are so many different approaches that have been presented now about the terminology, methodology, etc., and also to some extent interdisciplinary approaches. So I think Panos and his team has much to do, and I agree with Andreas that it's rich possibilities for future conferences or whatever. Yeah.
Thank you very much, Geir. Because I know everybody's tired, Harlan, we definitely know that it's very early in the morning. Although you know the early bird gets the worm, so but in your case it was perhaps a little bit too early. Allow me on behalf of all the organizers from TRICI-Law, Pluricourts, and TLS to thank firstly our keynote speaker, Judge Liu Dakan, for honoring us and also being with us for both days despite his very hectic schedule. We thank you very much. Of course, to a wonderful host of chairs and speakers for their very, very informative, thought-inducing, and use any other adjective you want, and thought-provoking. I can go on and on presentations for their lively participation in this conference. And also, of course, to all the people that participated, either by simply attending or listening in. As Andreas and Geir suggested, there are some ideas about possible publications. We will in due course pester you with some messages on this. one request, because of course we went online, I kindly request you again to the keynote speaker, the chairs, and the speakers to send us your address so that we can at least send you a small token of our appreciation for making this conference a reality and such an inspiring experience. So on behalf of all of us, thank you again. And I hope this is only, the beginning of our continued conversation on these topics. And again, a round of applause to all of you, and thank you very much for this. Thank you all, and have a nice rest of the day and enjoy your weekend. We'll keep in touch. Thank you again.
Thank you, Pano. Bye-bye.
Bye-bye.
Bye, guys.
Thanks a lot. Bye.